5, 4, 3, 2, 1. The appellant is said to have taken part in conspiracy in defrauding the bank. Full stop. Serious charges of falsification of accounts and forgery of records have also been alleged. Full stop. Although no charge against the appellant under the Prevention of Corruption Act has been framed, indisputably the officers of the bank are facing the said charges. Full stop. Para. It is now a well settled principle of law that in a given case, a civil proceeding and a criminal proceeding can proceed simultaneously. Full stop. Bank is entitled to recover the amount of loan given to her debtor. Full stop. If in connection with obtaining the said loan, criminal offences have been committed by the persons accused thereof, including the officers of the bank, criminal proceedings would also indisputably be maintainable. Full stop. When a settlement is arrived at by and between the creditor and the debtor, the offence committed as such does not come to an end. Full stop. The judgment of a tribunal in a civil proceeding, and that too when it is rendered on the basis of settlement entered into by and between the parties, would not be of much relevance in a criminal proceeding having regard to the provisions contained in section 43 of the Indian Evidence Act. Full stop. Para. The judgment in the civil proceedings will be admissible in evidence only for a limited purpose. Full stop. It is not a case where the parties have entered into a compromise in relation to the criminal charges. Full stop. In fact, the offence alleged against the accused being an offence against the society, and the allegations contained in the first information report having been investigated by the Central Bureau of Investigation, the bank could not have entered into any settlement at all. Full stop. The CBI has not filed any application for withdrawal of the case. Full stop. Not only a charge sheet has been filed, charges have also been framed. Full stop. At the stage of framing charge, the appellant filed an application for discharge. Full stop. One of the main accused is the husband of the appellant. Full stop. The complicity of the accused persons was, thus, required to be taken into consideration for the purpose of determining the application for discharge upon taking a realistic view of the matter. Full stop. While considering an application for discharge filed in terms of section 239 of the code, it was for the learned judge to go into the details of the allegations made against each of the accused persons so as to form an opinion as to whether any case at all has been made out or not, as a strong suspicion in regard thereto shall subserve the requirements of law. Full stop. Para. The jurisdiction of the court under Article 142 of the Constitution of India is not in dispute. Full stop. Exercise of such power would, however, depend on the facts and circumstances of each case. Full stop. The High Court, in exercise of its jurisdiction under section 482 of the Code of Criminal Procedure, and this court in terms of Article 142 of the Constitution of India, would not direct questioning of a case involving crime against the society, particularly when both the learned special judge as also the High Court have found that a prima facie case has been made out against the appellant herein for framing charge. Full stop.